Court calls the case People versus John Brown.
Andrew Childers appearing on behalf of the people, Your Honor.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. John Brown, who stands to my right. What's your name for the record, sir?
John Brown, how you doing, Your Honor?
I'm doing very well, Mr. Brown. The court has before it a plea form. That's what we're doing today.
That is correct, Your Honor.
He's going to plead guilty to an added count 2 of use of a controlled substance, that being fentanyl, a misdemeanor punishable by up to 1 year. Upon successful plea to that charge, count 1 would be dismissed. And the sentencing judge waiver box isn't checked, but
Oh, I'm sorry, Your Honor.
Did you
We
explain
did
all of
go
that to
over
her?
that. Yes,
All
we
right.
did go over that, Your Honor. My mistake for not checking that box.
all right, very well. Could I have him sworn, please?
Raise your hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth? So you got it.
Yes, ma'am.
Lower your hand, state and spell your name.
John Brown.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
You understand that?
Yes.
All right. Still wish to plead guilty
Yes.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form or went over one with your counsel?
Yes.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of it.
Yes, Your Honor.
Are you on probation or parole?
I am on probation.
Were you on probation at the time of this offense?
No. Yes, I was.
You were? Okay, I do have to advise you then that your guilty plea in this case could be considered a violation of your probation. You understand?
Yes, I've spoken with my probation officer. She knows what's going on.
All right. I have to advise you that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, sir.
All right. And understanding that, you still wish to plead guilty to this charge?
Yes, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes,
and because you believe that you are indeed guilty of this offense?
I am guilty.
January 24th, 2025, at the location of 49230 Michigan Avenue in Ypsilanti Township, Washington County, State of Michigan. Did you have fentanyl in your possession?
Yes.
Had you used it?
It was in pill form. I didn't at the time. I didn't know it was fentanyl, but yes, I did take one. Yes.
So you didn't know you had fentanyl in your possession?
It was in a Percocet form. I thought I had bought a Percocet pill.
So you didn't know what you were using was fentanyl?
Ignorant. Nope, didn't know.
But you knew, okay, but it was a Percocet you thought you were taking.
Yes, I knew it was illegal that I didn't have a prescription
You
for
did
it.
not have a prescription for it. And so you were in possession of a controlled substance that you shouldn't have been in possession of,
Yes,
correct?
sir.
All right, then there's a number of ways I can do it. Higher.
Yes, Your Honor, I would ask
Take.
that take plea to the higher the
All right,
charge.
sir, if I accept your plea, I need to apprise you that if you commit misconduct as defined under Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
I understand, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule?
People are satisfied, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be February 12th, 2025 6:10 a.m. before Judge Washington.
Your Honor, may I address bond when appropriate?
I don't know if it's appropriate or not, but go ahead.
Thank you, Your Honor. It is my understanding, I was not the attorney at the last probable cause conference, but it is my understanding that Mr. Brown was remanded at the last hearing for a community corrections bond violation. It's my understanding he's been in jail a week on that violation, and the basis of it was 2 missed tests, as well as I believe a test that was positive for THC. I have spoken about this to my client. He, of course, admits to the bond violation. He did appear last week in court knowing that he was likely to be remanded on the bond violation. I do not believe him to be a flight risk. He does have a residence where he lives with his girlfriend and 4 children, ages 16, 14, 3, and 11 months in Taylor, Michigan. He further has full-time work doing cement and flooring. He's a finisher. He is asking if the court would consider reinstating his personal recognizance bond. He is willing to do anything that the court obviously orders. He understands he cannot have a single more missed test. To my understanding, his positive test didn't have anything else positive besides the THC. He's willing to go on tether. My client even told me he'd be willing to do house arrest. I advised him that is likely not the appropriate sanction the court would issue. However, he understands he's not to do substances. He needs to.
I'm not going to change his bond. What he's going to need to do is he's going to need to talk to the probation department there. And then in Judge Washington's good wisdom, decide to change his bond.
Understood, Your Honor.
Your Honor, first I understand you say you're not going to change my bond. I just want to apologize
But
to the
you're
court.
still going to ask me? No,
Yeah, I just want to apologize to the court for my ignorance and not knowing that I was supposed to go over there. But I really need to get back to work. Like I'm down. I'm willing to go on tether, whatever. I just want to be able to get back to work. Right now, my girl's not working. I got 4 kids at home. Very, very high rent.
Okay, sir, what I've indicated, and your counsel knows how to get through to 14B. They can contact 14B, get you interviewed, and then get to Judge Washington to reset your bond. But at this point, I'm not changing your bond. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Caitlin Quinn.
Andrew Childers appearing on behalf of the people, Your Honor.
And good morning, Your Honor. For the record, Brian Stacy, P33014, on behalf of Ms. Quinn. Morning, Judge.
Your name?
Caitlin Quinn,
Oh.
Your Honor.
Judge, at this time, I have filed an appearance, substitution of attorneys, and an order for substitution, and a request for adjournment today because I was retained yesterday to get discovery from the defender's office.
All right. Without objection, probable cause conference will January 29th work for you, sir?
Yes, it does, Judge.
January 29th, 2026, 9 a.m. bond continued.
Well, Judge, wait, may I address that? Because she's still,
No.
the bond on the ROA says personal, and she's still in jail.
Hang on. Check.
So I was confused why she would be there.
Yeah, I'm always looking right now.
I have it personal on the page. Yours shows what?
Right, yes. Which we have no objections to other than letting her go.
Is this their only case?
Yes, Judge, she has no priors.
Does she have a bond? But it doesn't say she's here on the bond, right?
While on bond, she's been testing. Her last test Thursday was negative. First test came back positive, and she said that's
She did
good,
have a violation
that she
from January 7th.
that she is that the one you appealed, the January 7th one? And I think that, and she appealed it, and I don't know if they got the appeal results. And
Okay,
she plans
so
on
here's
testing.
what I have.
Okay.
And the reason why she's in, her bond must have been changed. Did I issue a warrant on this? Or is she being held on that? Being held pending. Have you seen the bond violation?
I know that she tested positive, Judge.
Oh, she did.
Yeah, that's what they say, and then she appealed that. And those results are not back. And she tested negative last week when she was arrested on Thursday, and that was negative.
When did she? So on December 30th, you're saying there's a test after that one?
She indicates to me when you were incarcerated on the 8th,
When I got into jail.
which she was taken into jail on the 8th. Were you out on bond before that?
Just recently, last Thursday, when I tested and got into jail.
Right, that's when you tested.
Yes,
That's,
that's when I tested and
is
negative.
that the only time? Oh, that one was negative.
Yes,
Which one was negative?
She says when she went in on January 8th to the jail that one came back negative. But then there was one, why would there be one prior to that? Were you already on bond?
Yeah, she was already on bond. She
Okay.
was supposed to be testing, and just so council's aware, on December 23rd, she tested for numerous things. Well, she was positive for THC, which I don't think she has a card for.
She indicates she does have a card, Judge.
Okay, she didn't present it to them, but there were other things,
Not the card.
but I don't think she has a card for cocaine.
No, Judge.
Okay.
She is
Doesn't
on,
have a card for cocaine, and if that's not bad enough, that was on the 23rd. On the 30th, and I'm getting older, so I don't know. Did they have a fentanyl card? Because that's what showed up on that date.
that's why I can test it.
that's the one that she contested.
That's the one she's contested. So
Yes.
not the cocaine?
No, Your Honor, but she indicates she didn't use after on bond, she used immediately before bond. And I believe that was 6 days later.
She used the cocaine before she was placed on bond.
That's what she indicates to me, Judge.
Is it?
Yes, sir.
So when was December 17th, and it's showing up on the 23rd. Some good stuff.
What? Okay.
Yeah, I revoked her bond last time she was here
Okay,
because of those tests.
very good.
I am not inclined to change it at this point. It's gonna sit where it is.
Well, Judge, if I
If
may,
somebody needs, it's gonna sit where it is until I get the results on the fentanyl. If she's contesting this, there's fentanyl in her system.
okay.
What about my last test from when I got? into
Yeah,
jail?
what about the jail test on the 8th?
What?
What about her negative jail test?
I don't know. I don't have a report on the jail test,
Oh,
and I don't know what kind of test that was. I mean,
did
I
a
don't
urine
know.
test?
Yes,
Urine. So I'm assuming it was a drug panel.
it was like.
Right, but I don't know if it went over through our system at community corrections. I don't have a report on it.
Right.
So I don't know if it was clean or whether it was or not.
But she would continue to test, Judge, and I believe she would continue to test
She
negative.
had 3 tests. And 2 of those tests, I mean, absent her prescription medications, 2 of those tests were dirty for something. I'm not changing my decision. I will take a look at it again if I get that other test
Okay,
or whatever. If I get the other test that she says she took, if it meets with the certain standards, or if, I'll look at it. Or if the results of the challenge to the fentanyl comes back, then I'll take a look at that certainly also.
we'll address that on the 29th then, Judge.
Yep.
Well, thank you for your time.
Thank you. Court does call the case People versus Shalisa Floyd.
And that can be approaching.
Why is Cannon hugging people in the aisle? Your name, ma'am?
Oh, Shalisa Floyd.
Thank you.
Your Honor, requesting to adjourn this matter. We're still waiting for some discovery.
How soon do you have it? I mean, if we're waiting discovery.
So I believe it's supposed to, we requested it the other day and I was supposed to be receiving a link, a watch guard link for the discovery, but I never received that link. So,
You give it to them as early as next week.
so 2 weeks.
Can we, oh,
What did you want to say?
I was,
You wanted to say something?
yes, sir. I was just,
I'll talk to you. I like talking to you more than I like talking to them. So go ahead. What do you want to tell me, ma'am?
I was just gonna say 2 weeks because I'm starting a new job at Chrysler, so I don't know what my, schedule
Your
is gonna.
schedule's gonna be?
Yes, sir.
All right. So when do you start that?
Next Thursday.
So you start that on the 22nd?
Yes.
All right. And then you're gonna have to get to your attorney. Everybody's gonna have to look at it. While we're doing all that, you don't want to lose your job.
No, sir, I don't. Thank you.
And here's what I'm gonna do. I'll put the probable cause conference out to February 12th, 2026,
Thank
9 AM. And she's working and doing that. If she can find a way to get it done, then she submit the forms, let her appear via Zoom. And we'll try to time it up so she won't lose her job. You're welcome.
Thank you.
See, if they had said it, it would have all turned in and I would have just denied everything. But the way you asked. All right,
Address bond, sir.
pardon?
Can we address bond also, sir?
Your bond?
Yes, sir.
Oh, you're
if
telling
she
her what to
asked-
say now?
If she asks, you won't deny it.
All right, what about her bond?
My bond condition.
Your Honor, she has right now, there's a no go to her current house where she lives, so she's not able to go there. So we are asking if we could change that to allow her to go back home. Right now, she's been living at friends' homes and she's still paying rent and mortgage on that home that she can't go to.
Your Honor, the people that oppose a modification to the bond, no go to, especially as the complaining witness is currently residing at that location. He is in the process of moving out. He's asked us to get at least 2 weeks for him to be able to do so. But at this time, he would like the no go to.
Your Honor, it's her home and he has no right to be staying in that home at this time
So how do you get in there?
because there's the no go.
No.
Originally he was staying with her as, but
Yeah,
not as a resident there. It was just a one-time thing.
We were dating.
what?
We were dating. I'm in love with him. I am in love with him.
Okay, that's fine. I get that. And I guess that was gonna be my point. I understand it may be her home. But I don't really think if this court's gonna be consistent, I'm not going to change that where that person is still in the premises.
So in 2 weeks, he indicated that he's moving out within 1 to 2 weeks. Should we,
Well, here's the problem. Even if she doesn't, or he doesn't move, then she's just caught at that point. I'm not going to change it to allow him to go, or allow her to go back until he's just vacated the premises.
Your Honor, when we receive confirmation that he has left the premises, I'll reach out to defense counsel. We can submit a stip to allow her to return to the address.
Well, I've given him an eviction notice already.
Okay, that's gonna be a whole other problem. Because whenever people are in the middle of a domestic,
I didn't give,
where's the property?
it is 8359 Brookstone, Willis, Michigan.
I don't know if that comes here or not. It's in Washtenaw County.
yes, sir.
Is
Right next to Ypsilanti.
that 14B? Is it 18? Well, there's only, well, if it comes before me, I'm gonna throw it out because I don't allow eviction cases on domestic cases either, for very good reason. So he needs to just move. And then there'll be the stipulation and you can go back.
Thank you, Your Honor.
Okay, bond will continue.
Thank you.
Recalls case, People versus Lamar Johnson.
Or you getting on with people?
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
You're still under canon?
Yes.
Wow. I thought it was like a whole new semester. That's something good might happen for you. Okay, permission to practice.
Thank you, Your Honor. Can you state your name for the record?
Lamar Johnson. Thank you. What are we doing?
Your Honor, we're requesting to set 1484 for preliminary examination and an adjournment for 1487.
The cases aren't related. Really.
They are, I believe they are.
Pardon?
I believe they are related.
They are related, Your Honor. It's an RNO stemming from the home invasion. They're charged as two separate cases.
Got it. That's what I was wondering. So why would I do that? Set one for preliminary examination and then adjourn the other. Ms. Glenn.
Your Honor, our client is requesting a preliminary exam because he believes that
Back up, Cannon. Why would I set a preliminary examination basically on part of a case? I realize they're charged separately, but why wouldn't they be held together? Well, let me ask this. Wouldn't it make more sense if they were held together?
I think so. Mhm.
So I guess then where are we at with the one that you want the adjournment on that would stop us from going forth on a preliminary examination on that one? Hold it. Hang on a second.
Yes, sir.
Sir, you're good. Don't worry about it. Cannon sent you up here to do this, didn't she? And she knew. Ms. Glenn, you've been set up.
Your Honor, may I?
I think you're gonna have to.
I see this. The home invasion case, we're waiting for DNA on. I don't have the DNA back as of yet. And we do think that that is pertinent to the case.
Got it.
The RNO, in its, my opinion, is tangent to that. While they were out looking for a possible suspect, they allegedly came across him. So he's not in the house, he's not doing anything, he's just.
But is this like
kinda out and about.
shortly afterwards? I mean, the problem's gonna be, there's going to be some testimony, I would suspect, that relates to the one case to show that the officers were acting lawfully.
Your Honor, our client said it was 4 days after.
But even, I mean, go ahead, Mr. Cook.
Your Honor, so the RNO relates to the arrest on this, but it was a couple days later. They were searching for the suspect. If the court wants to set the RNO for exam, I think there's sufficient separate to where I could run that example.
Without mentioning or getting into the other one.
If defense counsel is willing to, I guess we can have a conversation about possible stipulations for exam purposes as to that. For strengthening the way to make this one suit.
It was like 3 days later, Your Honor, and I think it's even different officers. I mean, I guess they could say.
Right, but then the question becomes, does it not? Why are they I don't know what the alleged resisting is, but why are they detaining him? That then gets into these other events, right?
I know you really, no, I know you really want it said. I know you do, but what the court is saying is that they made.
I mean, I'll do it, but I'm just saying.
Why was they after me in the first place?
Okay, okay.
You gotta tell them that.
I understand. Just hold on. Your Honor, my client really would like to have his preliminary exam held. I can go over this with him again in more detail. We've discussed this type of stuff. He wants the exam. Are you holding it? I can work with the prosecutor on certain stipulations so that certain things may not need to come out.
The problem is, this is all gonna have to be, if I set it for the 27th, all this is gonna have to be explained to, here's what I'll do.
Thank you, Your Honor.
I'll give you your preliminary examination in person. That'll be February 3rd, 2026, 9 a.m. That's before me. So that we don't run into any problem with why this one is set and what the court's gonna require. Then in the other matter, you're seeking an adjournment.
Yeah.
When is the DNA expected back?
6 months.
That I don't know.
In this man. Will be adjourned. I'll just set it for February 5th, 2026. 9 a.m. bond continued.
Thank you, Your Honor.